I thought that was a great presentation. Okay, so next up, we're going to talk about some settlement issues. Chris King from our Birmingham firm is going to talk about the way plaintiffs are finding new ways to kind of have their cake and eat it too in terms of settlement. They're trying to find ways to retain settlement proceeds and then sue for more by alleging misrepresentation or suppression of material information in connection with the settlement. This kind of harkens back to Joe Ortega's earlier presentation about the ethics of certain tactics during settlement negotiations. So Chris is going to talk about lessons learned from defending these second bite at the apple suits and helping defendants achieve bulletproof settlements. Please welcome Chris King.
I want to thank the organizers for this awesome middle of the lunch hour time slot. I hope all of us have had the following experience. We've defended a tough case with lots of exposure, and then through what we will claim is adept lawyering, the case settles maybe for not very much money, for an amount that we believe is a great number for us. And maybe, although we claim it's adept lawyering, maybe the settlement is aided by the fact that the plaintiff's lawyers didn't do much right or didn't do much at all. And frankly, we just got to steal. We just got to steal. I hope we've all had that experience. And that's good, right? We represent our team, and the plaintiff's lawyer represents their team, and it's not our job to make sure they get it right. So, everything is fine. Then comes the routine paperwork, and if it's a settlement that requires court approval, then we rely on the plaintiff's counsel to handle that piece, right? After all, they're the ones that want their money. They have every incentive to get the court approval done so they can get their money. And so what our paper talks about in a situation where there is court approval is a class action court approval. But in fact, this issue can come up with settlements with minors or incompetence, or maybe in derivative actions. Any case in which there is a court approval process. So far so good. We've gotten a steal. We've settled the case. But here's where things can take a turn. Let's say that through a lack of diligence, ignorance of the true facts, or maybe in the plaintiff's lawyer's zeal to get the deal approved, get their check, maybe the plaintiff's lawyer says something to the court that's not right. That's not right. I was interested to hear Joe Ortega because, frankly, one of the ways this comes up is if the plaintiff's lawyer makes a representation to the court during the approval process about limits of insurance. Or maybe the representation is about the plaintiff's injuries and the defendant has medical records in its possession that contradicts those representations. So, this is a tough problem. This is a tough problem because it's not clear as a defense lawyer what the defense lawyer's duty is. So, defendants faced with a dilemma. Do I say something? But it's not that simple because most state ethical rules only talk about not making an affirmative misrepresentation to the court, right? And that's Rule 3.3 of the model rules. And the rule also imposes duties on us as defense lawyers to zealously represent our clients. So what to do? What to do? Let's say the defense lawyer is silent. And I'm not suggesting that that's an inappropriate choice. I'm not suggesting that. So the court approves the settlement. The court approves the settlement. And it's a done deal, right? We've got a release. We've got a court approval. Well, I think the answer is it depends. But in the nightmare scenario I've encountered, thinking the case was over, and in an insurance coverage dispute in which there is a transcript, the defense admits everything, admits facts contrary to what the court was told. And then there's a problem. So new lawyers get involved. Maybe years later, they now have transcripts where there's an admission that what that court was told was not correct. So, the court has been misled. So, lots of things can happen. Lots of things can happen at this point. But there is one thing I can guarantee us all will happen. The court is angry. Either that court is angry, if that court still is around, or the next judge is angry. And have you guys noticed that plaintiffs' lawyers seem to have Teflon? For some reason, when this happens, they're never around, they're judgment-proof, or they have had the good sense to pass away. So you say to yourself, well, look, they're the ones who made the representations to the court. The defendant is in the clear, right? In the clear. And that should be the case, and it could be the case, but sometimes it's not just plaintiff's counsel that get the blowback. And the purpose of this talk is to discuss ways in which the plaintiff's lawyer's uncorrected misrepresentation to a court, their sloppiness can blow back on us, and ways in which we might avoid that. First, to talk about the ways it can blow back. There are really three. You guys are all familiar with Rule 60, and there are actions under Rule 60B. There are actions for fraud on the court under 60D, and then we're going to spend some time talking about independent actions for fraud and suppression as well. So, recall Rule 60B. I hope you've never encountered it, because that means something's gone terribly wrong somewhere, but I suspect many of you have. And if you'll look at 60B3, there's a way to relieve a party from a judgment, in this case a settlement that some new lawyer is claiming is woefully too small, for fraud on the court. But look what it says. It says for misconduct by an opposing party. But it's there. It's there. Also, there's 60B1, which is not as sexy for the plaintiff in this situation. There are some things that help us with Rule 60 motions, one of which is time. But if the plaintiff is successful going this route, here are the possible consequences. The whole thing is reopened. The settlement funds are returned, and we've got the dreaded sanctions problem. But worse for the clients is that bargain that the client worked hard for, that good deal is gone. I put in the paper and in the PowerPoint some defenses, some things to do if you are the lucky recipient of a Rule 60B action. And the language from the courts are pretty good, but remember this. We're walking into court with a judge who is angry at everyone. Ethical rules be damned about what the defendant's obligations were. The judge is angry at everyone because the court was misused and the court was misled. So the second way a new plaintiff can undo our good deal is to move to set aside the judgment for fraud on the court under 60D. Notice here there's no fraud by the opposing party. It's just a fraud on the court. So we're back to Joe Ortega's dilemma this morning. Let's use insurance coverage as an example. About trying to defend the line that defense lawyer decided to draw about what the court would be told. And it's one thing to be asked a question by the court and to respond inappropriately. We all know that's a no-no. But I'm talking about a situation where the other party is the one who passed on the bad information, but information that the defendant knew was not correct. And 60D3 is a little scary because it's more loosey-goosey. And it does provide the court with the opportunity to reopen the case. And we'll talk in a minute about this third bullet point. In that situation, under 60D3, the court would have to restore the parties to the status quo ante, which would mean give the money back. And of course, there are sanctions problems, but even more important than sanctions problem, again, we lose our good deal. We lose our good deal. And again, there are things to talk about if we are subject to this. And the second bullet here is important. It's not something that we lawyers regularly run across, but it is the law everywhere I have looked that if a defense lawyer breaches a rule of ethics, and we can debate again whether sitting silent is a breach, but that does not provide a cause of action. And there is good language about 60D, in cases involving 60D, about how hard it is for a plaintiff to reopen a judgment under that provision. But they're out there. They're out there. The last prospect I want to talk about is, I think, the scariest for the defendant, and it's the one the plaintiff likes, and that is an action, an independent action to get a do-over. And there are a number of cases, believe it or not, that say a plaintiff can retain the settlement proceeds and then sue the defendant for the difference in what the settlement would have been had the truth been known and the amount the plaintiff got. Not to mention punitive damages, because we start the process with a court being misrepresented too. And we've seen these cases. They're around, and they're scary because of that next to last, well, I'll say the last two bullet points. Lawyers in the room. First of all, we're dealing with punitive damages. Second, then all bets are off. The subject of the lawsuit is now what the lawyers knew and when they knew it. So all of a sudden, all of the lawyers' files are discoverable. And we all, in our routines, put things in those files we sure don't like when we see them 5 years later. I think we're all getting better about that. There's some things to talk about. There's some things to talk about if that is something that happens. There are statutes of limitations. There are rules of repose. I've seen these cases where there's literally a 10-year lag between the settlement and a reopen. But again, bad facts and outraged judges make judges stretch the rules sometimes. I mentioned this earlier. You say, well, gee, the plaintiff's lawyer is the one who didn't tell the truth. Lawyers have been really good getting state legislatures to pass pretty good statutes of repose for them. And what I've seen in these cases is those legislatures have not been as kind to corporate defendants. And so sometimes there are cases that are clearly barred against the offending parties that may still be alive with respect to our clients. So, there's the nightmare scenario. How do we protect ourselves? How do we protect ourselves? I think there are some ways on the front end, and I hope that's the takeaway. The traps that I have seen involve discovery responses by defendants. How many times has this happened to you guys? I answer discovery early in the case, settlement discussions commence. I never look at my responses again. But in a lot of places there are duties to supplement What happens if some fact surfaces, some document is created that would be called for under my state supplementation rules? And I never think of it again. I do now, after having handled some of these cases, but we need to make sure our skirts are clean with respect to discovery responses, even if the parties have been in settlement negotiations for months. Number two, this is obvious, statements to the court. There are a couple of ways to walk this line of not violating ethical rules, continuing to represent my client, and making sure the court is told nothing wrong. One way is to pull plaintiff's counsel aside, not to make a statement to the court itself, but to try to make it better on the other side. Number three, I don't even need to talk about. We need to tell people the truth. So, what other things can we do to protect ourselves? And I think we can do these on the front end, and they're easy. And a lot of times when we settle a case, we make sure the release is right, that paragraph, and we pay little attention to else. But I would suggest to you, in a court approval case, in a case where it's going to the court, there are some things we can do. We want to get the broad release. We want to get language that says the plaintiff is not relying on any representation by the defendant, that the plaintiff has all material information they think they need to evaluate the settlement. And then, maybe most important, and this is where I have seen us not think through these issues, it's pretty easy to put in the settlement documents that plaintiff bears the burden of court approval, and even overtly say the defendant is not going to say anything at this hearing. The defendant will take no position with respect to the settlement at this hearing, and the defendant is not a proponent of this settlement. Now, the reason those words are important is there are cases that say once adversarial parties come together and reach an agreement, then they are jointly proponents of the settlement where their misstatement might be imputed to us. So I would suggest to you that if we spend a little time on the front end, we may save time on the back end. This is the takeaway. Thank you all very much.